Jose De Castro. Good afternoon.
Good afternoon, Your Honor. How are you?
I'm good, thank you. All right, Mr. De Castro, this is an obstructing or false info charge. It is case 24-006842. Obviously, I'm going to ask you, you understand your proceedings are being filmed?
Of course.
Okay.
They're here because I'm here.
Right, okay. And just so that the record's clear, you have no objection to that?
Of course not.
Okay.
I would like the transparency. I appreciate
Oh, no, that's
it.
fine. I need to ask that. City, there's no other issues for you with respect to this being filmed?
No.
Okay. All right, Mr. De Castro, did you get a copy of the complaint?
I did. Only question I have is who's the prosecutor? What's the prosecutor's name?
Well, let me ask a couple questions, and then we'll get into what your questions are. Did you review and understand this?
I don't understand it. I don't understand how I can be charged with obstruction for filming a cop.
Okay.
It doesn't make any sense to me.
So I'm asking a much more basic question. You do not have to agree with this. This is
Do I understand I'm in charge with the misdemeanor?
Yes.
I do understand I'm in charge with the
Okay,
misdemeanor.
that's literally it.
I have trial tomorrow for the exact same thing 1 year ago.
In this jurisdiction?
Yeah.
All right, folks, buckle up. Because today's courtroom spectacle is not just another routine arraignment. This is a long-awaited collision between internet activism, ego, and reality. The man standing before the judge isn't new to this system. He's built an entire online persona around provoking law enforcement, recording confrontations, and selling himself as a champion of constitutional rights. But here's the twist. Today, the camera isn't his weapon anymore. It's the courts. And that changes everything. This case isn't about free speech in the abstract. It's about where that speech ends and obstruction begins. It's about whether shouting First Amendment like a magic spell actually protects you when you ignore lawful orders. And most importantly, it's about how confidence can turn into catastrophe when you underestimate a judge who has absolutely no interest in YouTube theatrics. Stick around, because what starts as smug certainty will unravel into warnings, denials, ego checks, and consequences. This is the moment online bravado meets the real-world justice system, and the system does not care how many subscribers you have.
Okay, well, I don't want to get into any of that.
Sure.
Today, we're just here for purposes of this. It's a very procedural type of thing today for the arraignment. So you do understand what you got charged with. You do not have to agree with this. This is just an allegation. So you don't need me to read it to you.
I don't.
Okay, very good. And are you planning on hiring an attorney to represent yourself?
I will have a standby attorney for this case.
You will have a standby
Yes.
attorney. Okay.
Because I think that I'm going to win this easy. It's on film, and I wasn't obstructing anybody.
All right, Mr.
Is this the prosecutor, Matthew B.
Okay,
Walker?
let me do my part first, and then we can get into what it is. So, because I need to know, are you proceeding on your own? Do you want to have an attorney? Because I will give you time to talk to an attorney on your own if that's the route that you would like to go.
I will have a standby attorney for
Okay.
this case.
So typically, I would set this for a pre-trial to give you an opportunity to obtain discovery and for your attorney to find out whatever all is associated with this.
Sure.
So I can set that over for a pre-trial date to give you the opportunity to do that. Would you like to do that?
That'd be great.
Okay. And then what is it that you need to tell me without talking about the facts?
I just need to know if this is the prosecutor's name. Is that the person prosecuting, Matthew B. Walker?
That is a good question. I will tell you that the city attorney is Jeffrey Dorokat, and that's the person's name on the upper left-hand corner of the complaint. Matthew Walker is a deputy city attorney who actually prosecutes this case. Depends on the office.
I'm going to sue him for malicious prosecution.
Okay.
I'm going to sue everybody involved. I'm going to sue the cops.
So
I'm going to
Mr.
sue the
Castro-
county.
And here's where the pattern starts to show itself. Notice how quickly the conversation shifts away from understanding the charge and straight into disbelief. This isn't confusion, it's deflection. When someone says, "I don't understand how I can be charged," what they often mean is, "I don't accept your authority to charge me." That distinction matters. Courts don't require agreement. They require acknowledgement. What's also important here is a defendant's reliance on repetition. He's faced similar charges before. He's recorded similar encounters before. And he's walked into court with the same strategy before. Confidence through familiarity. But familiarity doesn't equal immunity. If anything, repeat behavior tightens the spotlight. Judges notice patterns and prosecutors document histories. This moment is deceptively calm, but it's laying the groundwork. Because when you repeatedly claim victimhood while broadcasting your own conduct online, you hand the court something invaluable: context. And context is what separates misunderstanding from intent.
Appreciate you have an opinion. Today's just the arraignment.
I got you.
Saying all these things,
you're
we're
just-
here
you're
for
just
your
getting-
misdemeanor case,
Sure,
okay?
but there's a bigger issue. There's transparency in the courtroom, which is the best thing that could possibly happen.
That's
Now the
fine.
people get to hear that I'm gonna sue Jeffrey, and I'm gonna sue Matthew, and I'm gonna sue every one of
So here's what
those
we're not
cops.
gonna do, Mr. DeCastro. This is not going to be a personal pulpit for your, philosophical difference or belief. You have the media here, and that's fine. This is
Great.
an open court.
It's
But
great.
I don't want you to start saying things too far extraneous for purposes of this misdemeanor charge, because
Well-
that's what, no, do not interrupt me. Because that's what we're here for, okay? So here's the thing, I'm recording everything, and you need to be aware that that's a two-sided thing. You're representing yourself, so I'm having this conversation with you. All these statements that you're saying can also potentially be used against you because you're getting recorded. So just so you understand. So here's what we're gonna do. I'm
Does the-
assuming you're entering a not guilty plea,
Does the
correct?
misdemeanor carry jail time?
Possibly, yes.
Possible jail time. So you said a second ago that this is a misdemeanor case as though it's something minor, but I can be put in a dungeon and locked away.
Okay.
Yup, that's absolutely what's about to happen to you.
In no way
So that's true.
did I imply that this was minor
Okay.
by
Yeah, it's a big
saying
deal.
that it's a misdemeanor.
It's a big deal.
Okay.
Okay,
Mr.
thanks.
DeCastro, let's not get off on the wrong foot. I have my job to do, and I'm not trying to engage in a conversation that's adversarial with you today.
No, I'm not
I
trying to
would
either.
like-
I'm not trying. I like you a lot. I think you look like a real nice person.
Okay.
I got nothing against you
So we're
personally.
going to enter a not guilty plea
Thank
on
you.
your behalf
Thank
today.
you.
I'm going to reset this for a pretrial. I do need to understand, because you said you were going to have standby counsel, so are you going to represent yourself primarily, or do you want to have that conversation come back with your attorney? Because there's certain procedural things I'll need to do to protect due process and your due process, if you want to go ahead and represent yourself.
Right. No, I'm going to have a standby attorney, and that has to do with a few different things. But I should probably consult with my attorney before I say anything, because it could be used against me later.
Absolutely, yeah, that's fine. And I would rather that you protect yourself, because we're recording, and that is where I'm coming from in the kind of conversations and comments that I'm making to you today. So you are obviously entitled to represent yourself, that is your right. But let's do this, let's get you a pretrial date, and that date, ordinary course for private attorney will be
May 1st at 1:30.
May 1st at 1:30?
I think I have.
Do you need a different date?
I may. I may need a different date because I have a different thing in Indiana. I'm just not sure. Can I just look in my phone real
Of
quick
course.
at my calendar here?
Right here, this is where ego officially enters a courtroom. The threat to sue everyone involved isn't a legal strategy. It's posturing. And judges hear this constantly. Lawsuits aren't intimidation tools. And courts don't flinch when someone announces future litigation, like at a mic drop. What's especially telling is the assumption that naming prosecutors and officers publicly somehow grants leverage. It doesn't. In fact, it often does the opposite. When defendants announce legal warfare mid-arraignment, they're not projecting strength. They're signaling emotional investment and poor impulse control. Judges interpret that as a warning sign, not a power move. This is also where transparency gets weaponized rhetorically. Transparency isn't about performing for an audience. It's about accountability. And the irony here is brutal. The same transparency meant to expose the system will ultimately expose the defendant's own words, demeanor, and choices. Courtrooms don't forget, and recordings don't take sides.
And Your Honor, I have absolutely nothing against you. I'm not in any way adversarial to you at all.
Okay, I'm glad to hear that, Mr.
I just,
DeCastro,
you know,
because we may be
Yeah,
on this case
yeah,
for
I
a
have
while.
nothing against
Okay.
you. I don't know you. You seem like a nice person to me. I couldn't possibly hold anything against you personally. So I'm just looking for the date that I have in Indiana. I sue lots of cops all around the country. I help sue lots of cops around the country if they violate people's rights. So I have a case in Indiana that I'm just looking for the date. And that May 1st,
Yes, at 1:30?
can't talk, I'm in court. Judge is looking at me.
Is it easier if I give you a different date and then you look at that?
Well, I'm just not sure if it's May 1st or June 1st. I'm just gonna go there because I'm assisting with the financing of filing a federal civil rights lawsuit against these cops who arrested this man for filming cops. So I just want to make sure that I'm there when that happens. You know, I mean, it's a lot of work, so he's texting me back right now. I'll know the date in 1 second. I hate to waste any of these people's time
You're
at all
not wasting
whatsoever.
anyone's time.
I just want to make sure that, because then we have to reset it again. If it's possible for my attorney to be here and me not to be
Absolutely.
here, well, then we can set it for any date that's most convenient for the court.
That's fine. You
Cool.
will need to inform your attorney of that date, and then
Okay.
I'm sure they will know to appear for you. If nobody's there on that day, that would be a problem.
That would be a bad thing.
Right, so you would need to be here if in fact this is not your attorney that you're gonna hire, because then I need to figure out, do you need any more time, or?
No, I already have an attorney retained.
Okay, so we will keep the May 1st, 1:30 date for your standby attorney to appear for you, and you do not need to appear on that date as long as your lawyer is here.
What time is that at, ma'am?
1:30 in the afternoon, and you are in Department 1, May 1st.
Department 1 at 1:30.
This exchange is critical. Watch how quickly the tone changes when jail time is mentioned. Misdemeanor suddenly stops sounding minor when consequences are spelled out plainly. That's not the judge escalating. That's the judge clarifying reality. Courts operate on precision, not vibes. When a judge says possible jail time, they are not threatening. They are informing. And the defendant's attempt to reframe that as exaggeration is telling. It reveals a common misconception among self-styled legal activists that misdemeanor equals harmless. It doesn't. What's impressive here is the judge's restraint. Despite interruptions, exaggerations, and emotional language, the court stays anchored in process. This isn't about winning an argument. It's about protecting due process, even from someone actively trying to derail it. And that patience, it won't last forever.
Good morning, Agnes Botello for the state.
Are you Mr. DeCastro? Can you turn off your phone, please? The one that's in your hand?
Just communicating with my lawyer. He's on his way here now. So I'm just waiting for him to get there.
All right, I'm gonna wait for your attorney, okay?
Okay,
Thank you.
thank you.
All right, Jose DeCastro, 23 CR 013015.
Good morning, Your Honor, Agnes Botello, and Kate for the record. Good morning, state.
Good morning, Michael Lee on behalf of the defendant present with me this morning.
So I have signed 2 media requests that permit recording or photographing these proceedings, but I have not granted any other requests to record or live stream these proceedings. So I need Mr. DeCastro and everybody else who wants to stay in the courtroom to surrender their phones, or you can leave.
Are your phone covered and I'll take one, or you can exit.
I need Mr. DeCastro to empty all of his pockets.
What's that?
Yeah, empty your pockets and give up your phones to the judge.
Okay.
I have to give you my phones?
Yeah.
My phones have to be completely off.
Yep. I don't really want to be part of your YouTube channel. So,
You already are.
great,
You already are.
awesome.
I'm not gonna get into this guy though. I'll get into someone else. I'm not touching myself.
No, they're gonna go to my marshal.
He's a pig.
Excuse me?
I said he's a pig.
Okay.
That joke lands because it's earned. Sarcasm in commentary works when behavior invites it, and this behavior absolutely does. What we've seen so far is someone who believes court schedules revolve around his calendar, his lawsuits, and his filming projects. That's not how courts function. Courts move on court time, not content creator time. And while flexibility exists, it has limits, especially when the court senses delayed tactics or performative confusion. The more someone overexplains their importance, the less persuasive they become. This moment also highlights something subtle but important: credibility erosion. Every unnecessary tangent chips away at how seriously the court takes you. Judges aren't impressed by busyness, activism, or online influence. They're impressed by clarity, compliance, and respect. And here, all three are slipping fast.
So I'm not gonna permit you to speak to anybody in my courtroom in that manner. And if you don't want to apologize, I'm gonna hold you in contempt.
I apologize to the court, Your Honor.
No, you can apologize to, they've done nothing to you.
Actually, Your Honor, when you were here, you came over and gave me a directive for no reason and started telling me what to do.
Okay, well.
I have all the respect in the world for the court. I follow the rule of law all the time.
No, it is their job to maintain the safety and security of the courtroom.
I agree with you, Your Honor.
So if you want to speak like that in my courtroom, I'm going to hold you in contempt. And if I hold you in contempt, you're going to jail. That is not my wish. Okay?
I wish you would.
All right. So I need you to empty your pockets too. Suit pocket, pants pocket.
This is illegal. This is a violation of my Fourth Amendment.
No, it isn't.
Yes, it is. I don't have any recording devices on me. What are you talking about?
How about your suit jacket?
I don't have anything on me. This is preposterous.
No, it's
This really
not.
is.
No, it's not.
Yes, it is.
Mr. Me, your phone too. Off.
They're recording everything.
They have a media request.
Right, and I'm not recording anything. Your guy here took my phone, so his phone's not on.
Right.
You have to take the lawyer's phone too?
No, I'm not going to take the lawyer's phone. He's an officer of the court. All right. Do we have everybody's phones? Are they off? All right. Good. All right. All right. This is the time set for the trial of State of Nevada versus Jose De Castro, 23 CR 013015. Is the state ready to proceed?
Yes, we are, Your Honor.
How many witnesses do you have?
We anticipate one.
All right. Is the defense ready to proceed?
Yes, Your Honor.
All right. I have your request to convert counsel to standby counsel. I'm going to deny that request. Either you represent him or he should have previously requested a Feretta canvas to represent himself. That I just consider that a delay tactic, so that request is denied.
This is where things cross from careless to catastrophic. Insulting court personnel, even indirectly, is one of the fastest ways to torch judicial goodwill. And make no mistake, the judge hears everything. The record hears everything. Contempt isn't about hurt feelings. It's about maintaining authority and order. When someone disrespects the officers responsible for courtroom security, the judge doesn't see rebellion. They see risk. And courts do not tolerate risk. What makes this worse is that it's completely avoidable. Silence costs nothing. Respect buys protection. Instead, emotion takes the wheel, and now the defendant is negotiating consequences instead of rights. This is the pivot point, the moment where arrogance starts carrying a measurable price.
Does the defense have any witnesses?
Your Honor, I call Jose De Castro.
Okay.
Raise your right hand to be sworn by the clerk. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please be seated.
Mr. De Castro, before you testify, I'm obligated to inform you that you have the right to testify in this proceeding, but you also have the right to remain silent. And should you choose to remain silent, I may not hold that against you in making my decision. Do you understand that?
I do.
And do you still wish to testify?
Yes, I do.
All right, please go ahead.
You have a YouTube channel.
Yes, I do.
Can you give some insight into what that channel was about?
Objection, relevance.
What's the relevance?
Your Honor, the relevance is that we're presenting a First Amendment defense, and the defendant is a member of the press. There's different standards for First Amendment rulings where there is public policy at issue. He can give insight into that.
I'm going to allow it for a bit and see where it goes.
Yes, I do have I do have a YouTube channel, and the reason I have a YouTube channel is because of how many cops kill people every year, how many cops hurt, maim, torture, rape, and kill people every single year. It's such an epidemic that the rest of the world, I get thousands of emails saying, only in America does this happen. I started filming cops because when I was cheated in 2002 and
Objection at this point, relevance,
well, this is the British member of the press.
this narrative.
So can you ask him a question?
Yes, Your Honor. What type of films do you make for your YouTube channel?
I only film police in their official capacity. I'm known across the country and across the world.
This denial is devastating and legally sound. Courts are highly suspicious of last-minute changes in representation because they often signal delay, confusion, or manipulation. The right to self-representation exists, but it must be exercised properly and on time. Standby counsel isn't a loophole. It's a structured safeguard. Trying to switch roles mid-trial undermines the court's ability to proceed efficiently. And when the judge labels it a delay tactic, that label sticks. From this point forward, momentum is gone. The The defense is reacting instead of steering. Every procedural misstep compounds, and the court is no longer inclined to accommodate improvisation. This is what happens when strategy is built on bravado instead of preparation.
And why do you engage in that type of filming?
So I'm going to ask you, Mr. Mead, to direct your questions about the incident in question.
The reason I was filming Mr. Dwork that day?
Objection, Your Honor. Oh, sorry. There
So,
wasn't a question posed, so I'm not sure what he was.
Mr. DeCastro, on the day in question, why did you approach that vehicle?
I was filming that cop because that's what I do for a living. I am a member of the press, and I invoked my right to be press. I always invoke my right to be press within the first 10 seconds of engaging with police, and I have thousands of videos that prove this.
so this is how you make money.
This is not how specifically I make money. I make money from selling legal documents to people.
And there it is, the collision between internet myth and courtroom reality. This case was never about filming police in the abstract. It was about compliance, boundaries, and credibility. The judge didn't silence speech. The defendant buried his own defense under ego interruptions and preventable missteps. Courts don't rule on vibes, followers, or slogans. They rule on conduct, evidence, and procedure. And every moment we watch today reinforce that truth. Confidence without discipline becomes liability. Activism without restraint becomes obstruction.
Okay, go ahead.
Do you recall the officer telling you to back up?
Yes, I do.
And what did you do after he told you to back up?
I took a couple steps back. I just showed him that I was willing to back up a little bit. However, if I may, in Arizona, they created a 10-foot law.
Objection, relevance, we're not in Arizona, it's the state of Nevada.
So I'm going to allow it because I think that goes to why he kept saying 10 feet in the video, even though I will take judicial notice that you're not in the state of Arizona, you're in the state of Nevada.
Well, a federal judge struck it down, Your Honor, and what...
Stop. Can you ask him a question?
Yes, Your Honor. Approximately how many feet did you back up?
I backed up a foot or two. I was at least 10 feet away from that car that the driver was pulled over in.
And when you spoke to the driver, what did you say?
Just after she was okay. The reason I film police is because they abuse people so often.
Do you recall the officer telling you not to speak with the driver?
Yes,
And did you make any statements to the driver after that command was given?
absolutely not.
Did the officer ever give you a specific distance to back up to?
No, he didn't.
If he did, would you have complied with that?
Sure.
Did you believe you were complying with the officer's commands?
100%. I also informed him I'm a member of the press, I'm a constitutional law scholar, that this is what I do.
Do you recall the officer explaining to you why he decided to arrest you?
There's several parts to the reason why he said he was going to arrest me. He said he was going to arrest me because I wouldn't turn my head a certain direction. If I didn't turn and face the car with my head, that he would place me under arrest instead of just giving me a ticket.